Hi, my name's Caroline.
My name's Anna.
And my name's Melissa, and we're doing our project on gay marriage. We decided to do our project on this topic because of the impacts that gay marriage has on businesses. May 18th, 1970 was the first time a couple applied for same-sex marriage. It was Richard Baker and James McConnell, but they were denied. Since 1970, numerous things have changed regarding same-sex marriages, which has led to the legalization of gay marriage in several states.
In 2012, after Obama announced he supported gay marriage, it was approved in 3 states, and the one attempt to ban it failed. After the Supreme Court ordered the federal government to recognize these marriages in 2013, a series of lower court decisions brought gay marriage to state after state like a string of firecrackers. No one doubts that in due course the entire country will join them. By 2013, nearly 60% had no moral problem with same-sex relations. The chart to the right shows when people were asked if they knew someone gay or lesbian, what they said. As you can see, from 1985 to 2013, it has completely reversed, and more people today know someone who is gay or lesbian. The questions we will answer in the following slides are: does the federal government recognize same-sex marriage? What is the Defense of Marriage Act? Does it still apply to today? Do homosexual couples receive the same benefits as heterosexual couples? And what is the definition of a spouse in marriage since the legalization of gay marriage? Trending legal issues. On this map in red shows the 35 states who have legalized gay marriage. Over 64% of the U.S. population lives in a state currently issuing marriage licenses to same-sex couples statewide. Does the federal government recognize same-sex marriage? Yes, it does, since the ruling of the Defense of Marriage Act unconstitutional. First, some information on the Defense of Marriage Act. The Defense of Marriage Act was signed on September 21, 1996. It is a federal law that allows states to refuse to recognize same-sex marriages granted under the laws of other states. It bans same-sex married couples from being recognized as spouses for purposes of federal laws, effectively banning them from receiving federal marriage benefits.
On June 26, 2013, the U.S. Supreme Court ruled that Section 3 of the so-called Defense of Marriage Act, DOMA, is unconstitutional. This court case set the precedent that the federal government cannot discriminate against married, lesbian, and gay couples for the purpose of determining federal benefits and protections. Why this case is such a landmark case is because Edith and Thea shared lives together in New York for 44 years, and after a 40-year engagement, they finally were able to wed in May of 2007. 2 years after, Thea passed away. When Thea died, the federal government refused to recognize their marriage and taxed Edith's inheritance from Thea's, even though they were married. Under the federal tax law, a spouse who dies can leave her assets, including a family home or other benefits, to the spouse without incurring estate tax. This video shows their lives spent together.
If you live together for 42 years and you love each other all those years and take care of each other all those years, how could marriage be different? It turns out it's different, and you don't know why. It has a magic word, which is magic throughout the world. Certainly it wouldn't have been as difficult if I had not had all of the money worries at the time. It's so hard to say why it matters, why marriage is different. But marriage is different. It has to do with our dignity altogether, our dignity as human beings, and our being able to be who we are openly.
Section 3 of the Defense of Marriage Act. The term marriage traditionally was between a man and a woman. The term spouse was often used as referring to a husband or wife. Now these terms are seen in a different light. The term spouse will now refer to any individuals who are lawfully married under any state law, including individuals married to a person of the same sex who are legally married in that state. The term marriage will now read to include same-sex marriage that is legally recognized as marriage under any state law. In this portion, we will be showing where our main focus lies. This will show the effects of same-sex marriage benefits on business. Big corporations such as Bank of America, Wells Fargo, Duke Energy, and other corporations alike have been changing their benefits to now incorporate same-sex couples. The same benefits that were available to heterosexual couples are now made available to homosexual couples. These are a list: health insurance, life insurance, medical expense claims, retirement, Social Security, and the FMLA Act. These are all now benefits that are available to homosexual couples. Health insurance. For coverages starting in 2015, an insurance company that offers health care to opposite-sex spouses must do the same for same-sex spouses. As long as the couple is married in a jurisdiction with legal authority to authorize the marriage, an insurance company cannot discriminate against them. Life insurance. After the Windsor decision, same-sex married couples may wish to revisit their life insurance needs. Life insurance can be used to mitigate financial risk of lost earnings, fund a spouse, retirement, or fund the education of a child. Medical expense claims. Windsor case also promotes 2 additional changes relating to healthcare coverage. Now an employee of medical expense claims. The Windsor case also promotes 2 additional changes relating to health care coverage. Now an employee's same-sex spouse can now have his or her health care expenses reimbursed from one spouse's account.
Retirement. As long as same-sex couples are married in state of celebration, each spouse will be recognized as beneficiary regardless of where their employer is based. Social Security. Couples in same-sex marriages can now be recognized by the Social Security Administration and can benefit from additional measures of retirement security that have been previously available only to heterosexual couples. The Family Medical Leave Act. This definition of spouse will now cover a partner, any legally recognized marriage, which means federal employees who have taken otherwise qualifying leave for a same-sex spouse since June 26, 2013, may now be able to retroactively redesignate such time off as FMLA. Now, our opinion on the matter. At the beginning of this project, we expected to find many businesses failing to comply with new laws pertaining to their homosexual employees. What we researched and found shows that we were wrong, and that many businesses are actually changing their policies and benefits to incorporate all people, including homosexual couples. While before we thought that there may be many outdated laws, we now know that a lot of these have been updated since the legalization of gay marriage. The Defense of Marriage Act is one example that is now ruled unconstitutional because of the legalization of gay marriage. It is also very interesting to see how fast people are becoming more acceptable of gay marriages, and how fast states are joining the list of legalizing gay marriage. An article from The Economist stated that no one doubts that, in due course, the entire country will join them, meaning legalizing gay marriage like the rest of the states.
In conclusion, we find that more and more states will continue to legalize gay marriage, which will lead to more changes. Some companies will not want to change their policies to incorporate same-sex couples, and it will be some time before homosexual couples get equal treatment at every business. Employers are having to continue to change their policies and benefits that they offer to employees so that they are equal and not discriminatory against same-sex couples.